Your Honor, I primarily am going to be relying on the motion. I do just want to note, after having received and reviewed defense's response, there seems to be two focuses there. One, that Mr. Kyle did not engage in any actual wrongdoing, and two, that any potential wrongdoing that may or may not have happened did not actually lead to the victim failing to appear. There was one statement in the first call
when the prosecutor walked into court without the very evidence their case depended on. This judge didn't just call them out. He detonated their entire argument. You're about to witness a legal grenade go off in real time.
Where the grandmother had patched in the victim, where she said specifically, I know, and I didn't, I still don't think there's a reason to put your hands on somebody though. And Mr. Kyle responds back, I didn't put my hands on you like that. And if I did, I apologize. To me, this is really the heart of the issue, is that he is persistent and consistent in telling her that she needs to call and tell them that nothing happened and that he didn't choke her. And this is the statement where she says, no matter what, that's not a reason to put your hands on somebody. And he says, I didn't. And if I did, I'm sorry. That's the heart of this. And if we're talking about wrongdoing, the content of this call is a continuation of the wrongdoing that we see in the initial incident, where he takes the phone from the victim and keeps her from calling 911 to call his grandmother, where she tells him not to call. She tells the victim not to call 911. This is a pattern of behavior that we're seeing continue on after his arrest and arraignment.
But isn't there even a more concrete statement where there's an indication where the defendant...
Let's be clear, video evidence is the spine of most modern prosecutions. But when that footage magically disappears from the trial, and neither side knows who has it, what we're watching isn't justice. It's chaos in a suit.
Is talking to the grandmother about communicating to the victim to change her story.
Correct. And I think that that goes beyond the direct contact between the defendant and the victim, and it relates to ongoing contact that has continued outside of the jail between the defendant's family and the victim. She is so in fear that she did not appear for preliminary exam, and I am concerned that she won't appear again, which is why we filed this motion, because of the defendant's persistence and pattern of behavior exhibited in the initial incident and then continuing in the calls.
Thank you. Thank you.
Thank you, Your Honor. And thank you for allowing us to have this hearing. My objective today is to show this court that the people cannot establish their burden even by a preponderance of the evidence. Just to clarify what the people have just mentioned on the statement that was just said about regarding putting their hands on someone. Your Honor, we're here for a forfeiture of wrongdoing motion. And if we finish that, the context of that statement, he also said, I did not, and if I did. So I just wanted to put that before I forget. I believe all three elements.
The judge here isn't just frustrated, he's stunned. How does a major piece of evidence vanish before a trial and no one bats an eye? What we're seeing is a total breakdown of communication and accountability.
Are in our favor, and I will use the standards set forth in...
Even if done through a third party?
Your Honor, I will address that.
No, you will address what I ask you to address, even if through a third party?
Even if through a third party, the elements?
If there's a statement made by the defendant to a relative, I believe a grandmother in this case, or his mother, indicating between the two of them to tell the victim to change her story. and then an acknowledgement that somebody will, why isn't that a wrongdoing?
Your Honor, that will go towards the clarity, the intent, and the purpose behind why to change her statement. And I was going to go through this element by element. And that question, the best response to that question is, if you go through the jail calls, which I'm sure you have, if you go through the jail calls, I'll just go through them now. In the jail call on March 26, 2024, in the motions at 8:25:55, Mr. Kyle called his grandmother, right, and Miss Lazarski. And if you look at the jail call at 3:05 into the jail call, so did you tell them I choked you? This is a question towards the complaining witness. Miss Lazarski stated, I didn't say anything to them. Okay, at this point, there's confusion. There's mixed testimony that we are trying to clear up. Mr. Kyle then followed, can you call up there and change your statement? Can you call up there and change your statement because
This is where the judge flips the power dynamic. He's no longer asking questions. He's issuing warnings, sanctions, possible mistrial, exclusion of evidence. In court, those aren't threats, they're fire alarms.
I'm sorry, because they are saying that. Then she responds, I'll call them and talk to them. So her intent is clear. Okay, and then grandma responds, they hear everything on this phone. So they are, and when you make phone calls from jail, we all know it says it's a recorded line. Mr. Kyle responds that it's not about them. They told me, you said that I choked you. They're telling me that you're saying I choked you. She responds, again, I'll call up there and talk to them. Mr. Kyle says, is that what you're trying to do? Question. Or do you just want me to leave you alone? Question. I get out, is that what it is? 4 questions. Answer to that question is, Your Honor, he's not calling his grandma to say, oh, fix her statement because she, her statement is concrete. Because what Miss Lazarski is telling him is she's saying, this never happened. I never told them any of this. So, and I highlighted in another call, on March 26th, the day before the arraignment, at 18:39:58, at 9 minutes and 47 seconds into that call, Mr. Kyle asks her, you said you had said what? And Miss Lazarski replied, that it's not how it went, and that I wasn't, and I didn't say any of that, and that I didn't want to press charges or move forward. Mr. Kyle replied, and I love that. Mr. Kyle replied, I mean, if that's how you feel, then of course go along with it. But you know, when I talk to you, here we go, it's completely different from what they are saying. So that is my response to that.
Why wouldn't that manifest an intent of some type? I mean, if what you're indicating to me is I'm supposed to garner some intent that it has to be something direct. I mean, why is he involved at all in the changing of what allegedly is said? Why?
At this point, the judge lays it bare. Discovery isn't optional. If the system lets the state spring video evidence at the last second, the whole game's rigged, and this judge refuses to play along.
Is he doing that at all?
That's a great question, Your Honor.
It is.
And thank you for bringing that up. And the response to that would be, Mr. Kyle is facing potential felony charges. He's not been arraigned yet. He wants to know exactly what's going on with what the police report saying, what the complaining witness is saying. Again, the no contact is not set in place. So Mr. Kyle's liberty is at stake. So I don't see it to be unreasonable for a situation like what Mr. Kyle and the complaining witness have gone through allegedly, for Mr. Kyle to call immediately on the mother of his child, the complaining witness, to clarify what is going on.
But he goes beyond just what is going on, doesn't he?
I respectfully disagree, Your Honor. I don't think it goes beyond what is going on.
He calls her and says, well, what's going on? This is what I hear. This is what you hear. Okay. But he does more than that. Doesn't he?
Your Honor, if I may.
Yes, go
He
ahead.
goes beyond asking for clarification. He makes explicit statements. He says to his grandmother, can you call her? I need her to change her statement. That's not a, can you ask her what happened? Can you ask her how she felt? Can you tell me what is going on? He says, can you call her though and tell her I'm on the phone so she can change my statement and I don't have to go through with felonies? Because I'm not even going to get out of jail until tomorrow. That's not a, can you tell me more? Or what's going on? I'm confused. That is explicit and direct and with intention. And it is exceedingly clear that this is a manipulation of the victim.
If that's how you feel, then go along with it. You are telling me you did not say any of that. So this isn't a, oh, well, go up to, let me call grandma and tell her to fix the statement. Fix your statement in regards to the truth is what's going on. If you are telling me you did not say that, but the police are saying.
The ruling hits like a hammer. The video evidence is out, gone. Not because it didn't matter, but because the rules matter more. The prosecution fumbled the ball, and the judge made sure the game didn't continue unfairly. This wasn't just about one case. It was a warning shot to the entire legal system. Get your case together or risk losing it all. In this courtroom, justice isn't delayed, it's demanded.
You said that, then just tell the truth.
Counsel, but your argument, the court would never, well, would rarely be able to find that there's any intent to do anything other than try to clarify. I mean, because I mean, it seems to me the argument you're making is that it can't be the context or the sort of totality of all that's being said into maybe said to various parties regarding this to express some intent of the defendant regarding this particular case. But that as I hear your argument, it almost has to be some express statement on his part.
Your Honor,
The court to find that there's intent.
Your Honor, I believe, if I may, I'm sorry.
Go ahead.
I believe there needs to be, and I've sat in on a motion, forfeiture motion hearing in this honorable court just last week, and I loved the court's analysis because it took the context of the call, of that jail call, and obviously this is completely different facts, different circumstances, but the court in its analysis almost made a spectrum of the context of the jail calls. It was the spectrum almost being don't show up, and if so, lie. And this was another case, not has to do with this. This case here that we're here for, I believe, is almost opposite of that. And that, don't show up and lie is egregious. It's undue influence. It's manipulation. It's obstruction. It's pressure.
But what would be the ramifications if she doesn't change her story?
Your Honor, that's something for the court.
No. I'm saying as between the two of them, what would be the ramifications of her not changing her story?
Well, Your Honor, technically she did change her story. She called up here.
Okay.
So, if we're going by the police report, correct. The ramifications of her not changing her story is detrimental. But I'm sorry. But if we're going off of her statement after this alleged,
Counsel, what I hear you saying is that, and all of these are very different in terms of what is said,